Welcome to this presentation covering Chapter 13. This is the chapter in the course in which we cover criminal law. So let's begin. By the way, if you find this topic interesting to you, we do have a course in our program that is about or covers criminal law much more extensively than this course does, and that course is LGLA. Oops, let me change the color here. What am I doing wrong here? Let me put it up here. Is LGLA 2313. It's an elective for both a certificate and AAS students, and it will go into much more detail than this particular lecture will provide. So if this topic interests you, I hope that you will find a way to sign up for this course. Let's begin. Oh, by the way, another thing about the title of this chapter to focus on is that really there are two topics here. We have a discussion about substantive law, which is when we talk about criminal law, that's what we're talking about, criminal substantive law. And then we also have a section on criminal procedures. Here we go. So if you think about it as being two halves, this is one topic here, and this is another topic. When we talk about substantive law, we're talking about the legal requirements of finding the particular causes of action, things like that. What are the elements, for example, of homicide? Things along those lines. Criminal procedures are the process by which a person travels through the criminal justice system. What steps are involved and what are the rules about how you go from step one to step two? What is the procedure, for example, to indict somebody? That type of information. Obviously, both parts are essential to having an understanding about criminal law, just like substantive law and procedural law are necessary to really understand any particular category of law. One difference about criminal procedure versus other procedural areas that we've talked about is that typically procedural law is kind of divided up into, you have the civil procedural law and the criminal procedural law. On the civil procedural side, in most respects, the same procedural rules apply whether you're suing somebody about, say, a breach of contract, or you're suing somebody about a tort, say a car accident claim or something like that. And in the majority of cases, you're just going to have one set of procedures that don't really vary so much depending upon the topic of the lawsuit. But we'll see that there are lots of different procedures in the criminal justice area. There's lots of reasons for that, but one of the big reasons is because of the constitutional protections that apply to criminal defendants. And we'll talk more about that as we go forward. So unlike most areas of procedural law, criminal procedures are very specific to that substantive area of the law, criminal law itself. So let's begin. Obviously, unfortunately, we have crime from time to time in our culture, and as a result of that, a fair number of people are arrested. The textbook says over 1 million people every year are arrested, and most of those individuals, ballpark about 80% of those individuals, that's assuming they're going to end up being prosecuted, and of course not everyone who's arrested does get prosecuted, but let's assume of the population that does get prosecuted, about 80% are going to be individuals who are eligible to have appointment of counsel, and the other 20% are going to be hiring their own attorneys. Plus, of course, each one of those cases needs to be prosecuted by somebody who is either employed by the county, say in the district attorney's office, or is employed by the state, say in the Texas Attorney General's office, or is employed by the federal government, the U.S. Attorney's Office, and there can be some other offices there as well that are involved in prosecutions. So there's lots of opportunities as a paralegal to be involved in the criminal justice system. You'll see more about this if you decide to take the criminal law course that we just talked about a couple of minutes ago. but there's opportunities for attorneys and paralegals on both sides of the aisle, both as prosecutors and as on the defense side. It's not at all unusual on the criminal justice side for individuals to start out on the prosecution side and to switch over to the defense side. We don't see that same transition nearly as commonly in the civil side. If a person starts out as a plaintiff's attorney, in civil litigation, they're probably going to spend their career as a plaintiff's attorney. If a person starts as a defense side attorney, he or she will probably spend his or her career as a defense side attorney. And that's maybe less true for paralegals, but there's still some truth to that. On the criminal justice side, though, there's less of a tie to or connection to a particular side of the law. As a result, there aren't the ideas or maybe as entrenched a tension between criminal justice legal professionals as there is on the civil side, because most criminal justice legal professionals have good friends and acquaintances on both sides. There's maybe more of a collegial, more of a community feeling within that group than you'll find on the civil law side. We talked that the public prosecutors prosecute criminal cases, and in Texas, those are mainly going to be district attorneys and assistant district attorneys, and they are commonly called ADAs and DAs. But there are also U.S. attorneys on the federal side. The U.S. attorney is kind of the equivalent of a district attorney. The U.S. attorney acts as a representative of the federal government in a particular federal district. And so while it's a very prestigious title to have, and a lot of status is associated with it, in terms of the day in, day out responsibilities, it's pretty similar to what a district attorney does. And then, of course, we have the state level. District attorneys are, in Texas, and my guess is most states, they're elected officials, so they don't actually report to the attorney general in a particular state. Attorney generals are also elected individuals, but in terms of the hierarchy, they are the local representatives of that particular county. On the defense side, it's a little bit more complicated because we have lots of layers here. For one thing, there are the understanding in our system that if a person can pay for his or her own attorney, someone who is a criminal defendant, then he or she needs to do so. Now, the state is not required to provide a defense for individuals who have sufficient funds for the defense. And so, but the reality is that most people charged with crimes lack the financial resources to adequately prepare a defense. And so in most cases, the vast majority of cases, they are eligible for the appointment of an attorney. And in that situation, then if it's a district attorney prosecuting, then it would be the citizens of that particular county that would be responsible for paying for that representation. Now, states can do this in lots of different ways. The main way that it happens in Texas is through appointment of attorneys. So there aren't public defenders who work, say, for the county who handle all of the indigent criminal defendants. You might think, well, if you're going to have 100% of the prosecution be from the district attorney's office and 80% is going to be from people who are paid for by the county, wouldn't it make sense to have a staff of folks who could work together and combine assets and office space and things along those lines? That is something that some jurisdictions have done, and it is something that could be explored in Texas, but it hasn't been part of our culture at this point in time. What happens is that private attorneys, and most of them are former ADAs, choose to put out their own shingles, work for themselves, and they are going to seek kind of two sources of income. One thing, they are going to seek criminal defendants who can pay their own way. Many times these are going to be people charged with DWI. That's a pretty common category of people who might be of a little bit more economic means, and of course, if they have the means, and they're required to pay for their own representation. That's one important source of income for most private attorneys who choose to represent criminal defendants. Another can be ticket prosecution, especially when it's a serious ticket. Um, the other category would be the appointment of two particular cases. And then, of course, if a person is appointed, then he or she is going to be eligible for a certain amount of compensation from the county. I will be honest with you, the compensation is relatively modest. Certainly it would be, compared to an hourly rate, it would be a very, very modest amount. So people don't become wealthy, and they honestly probably don't pay their bills based upon those public defender paychecks that they get for representing individuals. It used to be, once upon a time, that judges kind of had a free hand to appoint whoever they wanted to for these cases. But much of that has been standardized now, and there are procedures in effect so that the judge really can't or isn't in a position to play favorites as maybe once had occurred. So nowadays, in order to, for example, to be appointed to a serious felony case, an attorney has to demonstrate that he or she has handled a certain number of criminal jury trials in a particular category in order to kind of be eligible for consideration. And then you can get on the list, and then you're kind of given cases as they come up. So it's probably a more fair and regimented system than perhaps had once existed. In the federal system, there are some public defenders who actually work for the federal government, even though they are representing criminal defendants. But there are still attorneys who get appointments as well. So we see both systems in the federal system. And if you move to other states, you'll find that public defenders can, that there can be a greater use of the public defender system. As I said before, we see a lot of procedural differences between the civil procedure and the criminal procedure. And many of those differences stem from the protections afforded to criminal defendants in the Bill of Rights, which of course are the first 10 amendments of the U.S. Constitution. And so we'll be talking a lot about that. Criminal law is probably the one area in our curriculum in which we spend a significant amount of time talking about the U.S. Constitution. Obviously, the U.S. Constitution is an incredibly important document to our country and to the study of law. But most of us, unless we choose to practice in the criminal law area, don't on a day-to-day or even, an annual basis face constitutional law questions. It's just not a common area that you actually see those issues come up. And so that's an interesting aspect to the criminal law area. If you find constitutional law particularly compelling, you might find the criminal law course also interesting just for those reasons. Okay, well, let's get started. What is a crime? So here we're talking about substantive law. I'm just going to put sub on these slides so that we can keep track of where we're talking about substantive versus procedural. Well, the first thing to do is to think about what is the distinction between civil law and criminal law, because if we think about it in those terms, I'm just going to stop sharing for a second and look at a whiteboard here for a second. Okay, so if we think about this red as being criminal law, and this next one is going to be civil law. So let me go back here. And this is, we'll call this civil law. And we'll call this criminal law. And you can see that there's no overlap. A case is either one or the other. You would never have a case that part of the case is litigated as a criminal case and part of it is litigated as a civil case. Having said that, a particular event can be pursued as both a criminal matter and a civil matter. They're going to result in two different trials. And the reason for that is that if you were to combine the two in the same trial, it would get really confusing for the jury because they would have lots of different standards of proof. There would be certain times where certain constitutional protections would apply and other times where they wouldn't apply. And so it would be fundamentally unfair under our Constitution for that criminal defendant to face a mixed trial in those senses. But that doesn't mean that that criminal defendant is somehow insulated from civil responsibility for whatever that event is. So what would happen is one or the other case, it doesn't matter which one, would go first. And you'd have one jury that would focus just, say, on the criminal aspects. And then you'd have one jury that just focuses, say, on the civil aspects of the case. So, you can have an overlap where a behavior is both civil and criminal, but you'd end up with two trials. Now let's go back to our PowerPoint. Okay. So let's talk about why we have this bifurcation, because the reality is a lot of civil cases can have multiple theories. You might sue someone for breach of contract and a tort and a violation of, say, an employment discrimination statute. Well, you're not going to do those in three separate trials. You're going to have one trial over all those civil theories. There's still a lot that the jury has to keep track of. I mean, it can be daunting to have all those different things. So, for example, that jury might find that there was no breach of contract, but there was a tort and there was a violation of an employment law statute. Or maybe you'd find that there was a violation of the contract, but not the employment law statute. So there's lots of different permutations that you could have in that situation. But we always have that separation between civil and criminal law in terms of the actual trial that goes forward. So a crime is identified as an offense against society as a whole. Let's say that Bob punches Larry in the nose. Well, Larry has medical bills as a result of that, had to take some time off work, has experienced some pain and suffering. He wants to sue Bob for the injury. So in that situation, Larry's probably going to sue Bob under a tort theory. Probably he's going to allege assault and battery. But Larry also goes down to the police station and files a police report, and the district attorney ultimately decides to prosecute Bob for the crimes of assault and battery. They actually have the same name, although they have somewhat different elements. And so Bob is going to face two trials. In the criminal case, he's being charged with an offense against society as a whole. Yes, obviously Larry's going to be an important witness to the case, and the jury's going to, assuming that they buy Larry's version of what happened, is going to find Larry a sympathetic person. But the criminal justice system isn't focused on solving Larry's problems. It's focused on figuring out is Bob going to punch anybody else in the nose? Are other people at jeopardy because Bob did this? How has that changed kind of the social environments that we live in that Bob is going around and punching people in the nose? So it's really not designed to solve Larry's problem. If Larry feels he has a problem, Larry can sue Bob personally. Now, most of the time, Larry's not going to sue Bob because in most cases, Bob is judgment proof. Most criminal defendants don't have a lot of assets. And so, yes, Larry can sue Bob and probably get a big judgment against him, but it's not worth anything because you can't collect money from somebody who doesn't have money. You can't get blood from a turnip. And so Larry can sue him, but it's probably not that useful of an exercise. So because a crime is a crime against the whole society, not just against Larry. It's not Larry who punishes Bob, it's the government, the representation of that whole society. Criminal law is primarily statutory law. Let's go ahead and pull up the statute here. Here we go. I'm gonna go in here. If you ever want to pull up Texas statutes, you literally just type in Texas statutes. Your first hit here. And you go down here and just scroll down until you get to penal, the penal code. By the way, you can see that Texas statutes are organized thematically. There's a separate code for various topics. So for example, if you were looking into adopting a child, you look under the family code. If you were concerned about the rules about property rights and things like that, you go to the property code. If you're interested in the taxes in Texas, you look under the tax code. So they're arranged not based upon the year that the law was passed, but based upon the topic of the law. So let's go to the penal code. And you can see, you can go here and see the different statutes that we have. So let's say you're concerned about, we'll say criminal homicide. Let's go ahead and pull that one up. You can see you get more types of criminal homicide here. You can see right away that we have murder, we have capital murder, we have manslaughter, we have criminally negligent homicide. Let's just look at that first one, the types of criminal homicide. And you can see here, a person commits criminal homicide if he intentionally, knowingly, recklessly, or with criminal negligence causes the death of an individual. Criminal homicide is murder, capital murder, manslaughter, or criminally negligent homicide. So we have 4 categories here addressed by the penal code. Once upon a time, not that long ago, criminal law was case law. It was part of the common law, just like all the laws about contracts and torts are primarily found in case law. And in fact, most of the statutes we have in Texas aren't examples of the legislatures saying, boy, we really disagree with what the judges have done, so we're going to write our own statute to undo the silly decisions that our judges have done. No, in most cases, the legislature just codified what the rules already were in Texas. So they really, in most cases, weren't interested in changing the rules, but just putting them down in black and white that would be available to everyone. And the idea here is that you want your criminal laws to be especially clear, especially available, because you want people not to break them. And one strategy for persuading people not to break the rules is to make the rules really, really clear for everyone. Now, is it realistic to think that somebody, before they commit a crime, sit back and think, before I murder my spouse, I think I'm going to check to see if what I'm doing is a violation of the law? That's probably not that realistic, although there might be some more sophisticated crimes that a person might want to research it to see if there was a way around it, some way to trick the system or something. But still, the idea of having this be as transparent as possible is an important idea. And that's the reason why it's codified more commonly than perhaps other areas of law might be. So let's go back to our PowerPoint. Okay. Criminal cases require a higher standard of proof, and that is beyond a reasonable doubt. That's the standard. And this is designed to safeguard the individual against the power that the government has. I say state here, but I'm not talking about the state of Texas. I'm meaning the government generally. So it could be the federal government who is prosecuting. Let's pause and look at the different levels of proof that you can have in our system. The lowest level of proof is preponderance of the evidence. The highest level of proof is going to be beyond a reasonable doubt. There is a middle level of proof that isn't really that commonly done or required by the law, but it certainly has its moment, and that is clear and convincing evidence. I like to flag this one because sometimes people get thrown by it and think that when someone says clear and convincing evidence, that they're making a comment about, well, the evidence needs to be of a particular clarity or a particular level of convincingness. This is, and so the name I think is a bit confusing for some folks. no, the point is not that it's necessarily especially clear and necessarily especially convincing. It is a level of proof just like these are. So let's talk about what the levels are. For preponderance of the evidence, we're looking at 51% or more than 50%. That's the usual standard in civil cases. So usual standard in civil cases. It's not a very hard burden that the plaintiff has. He just has to persuade the jury that it's slightly more likely that his version is the case instead of the defendant's version. Let's jump to the other, which is beyond a reasonable doubt. We don't have a particular percentage, but the standard is if there is any reasonable doubt that exists, then you need to acquit the person. Even if you're 99% sure, but you do have a reasonable doubt, then that is sufficient. So you might say it's the maybe 97 to 99% situation. There is no particular percentage number, but if you have any reasonable doubts, you can't convict. If you have some hypothetical, really unlikely results, you can still convict. Let's imagine that I have been charged with murdering Bob. And I say that I didn't do it, my evil twin, who looks just like me, did it. But you know what? When they researched my birth records, my birth certificate said I was a singleton. And my mother testifies that, well, no, there was no twin. And there is nobody who testifies that I did have a twin. Well, I suppose there's a little bit of doubt. Maybe mom got paid off, and maybe there was an error at the hospital in recording my birth. But I think most of us would say that there is no reasonable doubt about that. And so in those situations, you find that if there really was no evidence other than this theory, that I'm not guilty, other than this idea that there might be an evil twin, that probably I'm going to be found guilty. Clear and convincing evidence is somewhere between these two extremes. And again, you can't put a percentage to it, but I'm going to, just to kind of give you a sense, it's probably about 75%. So as you'll hear the term that the jury has to have a settled feeling about the case, that they feel not certain, but they feel that there's pretty darn strong evidence that happened in a certain way. That it's more than this, toss a coin, I'm just slightly more likely in one category than the other. But, you really feel pretty strongly, yeah, I'm really leaning this way, but I can't rule out that couple of reasonable possibilities. Clear and convincing evidence is the least common of these three evidentiary burdens. It can apply in some civil cases, and there are even a few times where it applies in criminal law cases. So I wanted to introduce these terms to you. You will see some of these on the final examination and maybe even other tests, so be aware of how these terms work. I'm going to go back to our PowerPoint now. Okay. So one of the reasons that we have to have a higher standard of proof in a criminal case is that the individual has so much fewer assets than the state has. Even if we had Bill Gates or Donald Trump or another wealthy person, Mark Cuban, being prosecuted, even somebody who's that wealthy just has a pittance compared to all of the money that's available to the United States government. And so the idea is that it's such an unbalanced equation that we really need to have some ways of kind of leveling it out. We don't want to have a system where you can have a district attorney that's launching a personal vendetta against someone who's innocent. And one way to balance the authority of the state, the power of the state, is to require a higher burden of proof. Another thing some people wonder about is, does a crime need to have a victim? And it doesn't. Most crimes do have victims. If I murder somebody, obviously the victim is the person whom I have killed. But there can be crimes that are victimless. For example, if I speed, if I go over the speed limit, but I'm not involved in an accident, it's hard to see anybody who is a victim of that. If I am DWI, but I'm not involved in an accident, hard to see a victim. If I'm publicly intoxicated, hard to see, and I don't punch anybody in the nose or do anything like that, hard to see a victim. If I'm a prostitute and I engage in consensual sex with someone for money, hard to see a victim for that. Maybe in each one of those cases, society overall has been a victim, but we can't really point to a particular person and say, you know, Mary or Sally or Larry or Harry is better off because of that particular act. So we don't need to have a victim in a criminal situation. In a civil situation, though, you almost always do have somebody. At least that person has to allege that they have damages. If they can't point to some harm they've suffered, then in most cases they will not have satisfied the elements of that particular cause of action, and so they're going to be out of luck. So crime doesn't need a victim, but most civil claims are going to need a victim. As we said before, you can have civil liability for criminal acts. It's not at all uncommon. One set of facts can absolutely spawn both civil and criminal liability. Let's look at how that might play out. Let me go ahead here. Here's an example. We have a person, we'll say Joe. Well, actually, Joe is the victim in this situation. So Joe is attacked as he's walking down the street. Joe decides to file a complaint with the police, and so the police and the district attorney pursue it as a crime. The assailant violates a statute that defines and prohibits the crime of assault. In this case, in this jurisdiction, assault is attempt to commit a violent injury on another person. In addition, the person commits battery, which is the commission of an intentional act resulting in harm in another. The state decides to prosecute the person who assaulted Joe, and he's ultimately found guilty and he's fined or imprisoned. At the same time, Joe can be pursuing another set of another case through the criminal justice system. This can actually be before the crime is prosecuted, during the period of time the crime is prosecuted, or after. So in this situation, Joe is suing. So instead of it, in the crime situation, it's the district attorney acting as a representative of the state of Texas who's pursuing the case. But when we look at the tort, it's going to be Joe versus Bob, we'll say, is the assailant. So in this case, Bob has committed an assault, and now we have not the crime of assault, but we have the tort of assault. And here the textbook is, or at least the PowerPoint here is defining it as, and when this slide is from an edition of the textbook, so it is from the textbook, has defined the tort of assault as an intentional, unexcused act that creates in Joe an unreasonable fear of immediate harmful contact. You can see this is a lighter version, a less onerous version than we had over here with assault, because you can see there's no requirement that it be violent. And so you can have a harmful contact that doesn't actually result in a physical injury. For example, if somebody were to run up and kiss Joe on the lips, and Joe didn't want to be kissed on the lips by that person, well, that person has committed assault and battery against Joe for kissing him, even if there's no injury, and if Joe had wanted the kiss, it would have been a perfectly lovely thing to happen. But in that situation, it's very likely that while the tort of assault and battery occurred, the crime of assault and battery did not occur against Joe in that situation. Now, there may have been another crime that was committed, but not maybe a sexual crime that might be committed even with a kiss, depending upon the wording of the statute. But the criminal law requirements for assault and battery is more onerous, let me put it that way, than for the tort. So Joe files a civil suit against the assailant, and in this scenario, the court is, let's say Joe wins, the court awards Joe money for his injuries. So in the civil system, Joe gets paid. His problems there are fixed. The criminal justice system isn't going to give Joe any money. Joe may get some feelings of satisfaction at seeing Bob locked up. He may feel safer if Bob is incarcerated, but he's not going to get any money out of it. It's really not about Joe. It's about focusing honestly on the defendant. Let me go back to the slide that we were just at. Here is a way of comparing how the civil law system works versus the criminal law system. So we have here the area of the concern. Again, it's under the criminal law, we're looking at society as a whole. And that's why it's the state of Texas versus Bob. Under the civil code, though, it's much more about an individual against another individual, or a corporation against another corporation. It doesn't have that kind of big picture societal issue, unless, of course, the state or the federal government is suing or being sued. That can happen, but in that situation, it's still not, they're not really suing as a representative or being sued as a representative of the entire culture. It's more that they are pursuing a claim as the federal government or as the state government. Let's look at that wrongful act requirement. Okay, under the criminal law, you have to point to a statute and you have to claim and persuade the jury beyond a reasonable doubt that the defendant violated the terms of that statute. Under civil law, we're usually not talking about a particular statute, because most of these events that we're going to be talking about are going to be contract claims or tort claims, and most of the time in most jurisdictions those aren't statutory, those are part of the common law. So we're going to look toward the common law to see, well, what are the elements of that particular claim, and have they been satisfied? And of course, one of those requirements is going to be who was harmed and to what extent they were harmed. We don't necessarily need a harm under the criminal law, although most of the time there is going to be. And this relates, of course, to the next one: who is going to bring the lawsuit? Under criminal law, it's going to be the state, typically through the district attorney. And of course, the state could be the federal government. So we mean the government when we say the word state, not necessarily the organizational unit, meaning the state of Texas or something like that. Under civil law, though, the state's not going to be involved unless the state perceives itself as the victim in a particular claim. There are some exceptions to that. For example, sometimes the state will sue on behalf of people, and so then the state is, even in civil matters, then the state is acting kind of like a big brother to assist that maybe the poorly or potential person who was harmed who doesn't have a lot of assets. So there are some times where in civil law the government takes on that role, but the vast majority of cases, one person sues another person in a civil matter. Where I talked about the standard of proof, very different. We have preponderance of evidence in the civil thing, that's 51%. In the criminal justice system, we have beyond a reasonable doubt. What's the remedy? Well, the focus in civil law is going to be on solving the plaintiff's problems, getting him back to where he would have been if the defendant hadn't done whatever the wrongful act was. In criminal law, the focus is on the defendant, not upon the state. It's about how are we going to rehabilitate or punish or remove this person from society. It could be a fine, it could be imprisonment, it could even be the death penalty. Okay, and of course these slides here are still about, well, this is a combination of civil and procedural law. This is also a combination of civil and procedural law. We're back here, so now we're going to be talking about this first part here is substantive law, and I would say this is more procedural law. So we have three categories, and there's lots of different ways of dividing up the category of law. I'm going to flip over back to our whiteboard. So we're going to oops. Okay, I'm clearly failing at this. I'm going to do this. See if I can. Here we go. So we're going to divide it up like this. So we're going to have felonies here, misdemeanors here, and petty offenses here. Obviously, felonies are the most serious, misdemeanors are kind of the middle category, and petty offenses are the least serious. Sometimes a particular offense might lend itself to only one of these categories. For example, a parking violation. I can't imagine it being anything more than a petty violation. Whereas murder can be a misdemeanor, but I don't think it could be a petty violation. So sometimes the subject matter of the crime gives you some idea as to which category it's going to fall into. But even in those cases, there's a lot of discretion in how you're going to plead the particular claims. Sometimes it can have various penalties. Let's look for a second. I'm going to go back to that statute. We see we have 4 categories of murder here. Let's go down to okay, so we have under criminally negligent homicide. This happens if a person commits an offense if he causes the death of an individual by criminal negligence. An offense under this section is a state jail felony. So obviously we're not looking at the death penalty. Capital murder is a capital felony. Ordinary murder is a felony in the first degree. Let's see, where's manslaughter? A manslaughter is a felony of the second degree. So you can see that there are categories within this this particular crime, and that's not uncommon. For example, the unauthorized practice of law in Texas can be both a misdemeanor and a felony, depending upon the severity of the conduct. It's really left largely to the discretion of the prosecution. So this way of dividing up crimes are about the seriousness of the crime. Let's talk about the jurisdiction over crimes. The vast majority of criminal conduct is a violation of state law. For example, it's not a crime. It's not a federal crime to kill someone. Obviously, it's a crime under our state law. And the reason why it's not a federal crime to kill someone is that every state makes it unlawful. So there's no need to have federal laws about things that the states are already handling perfectly well. So as a result, there's relatively few things that are unlawful under federal law, but in most areas it's going to be unlawful under state law. The vast majority of crimes are prosecuted under state law. Federal crimes are oftentimes drug offenses. Tax offenses is another category. But there's not a lot of things like arson and murder, and bank robbery is a federal offense, but ordinary burglary and things like that, that's going to be addressed through the state court system. You may have heard the expression at some point in your life, don't make a federal case out of it. That's a comment on the fact that it's difficult to actually get into federal court and have a federal crime. You have to meet a lot of hurdles for the U.S. attorney to prosecute it as a federal crime. So that can be a way of remembering most of this stuff stays in state court. Even if it's a really serious matter, it's still probably just going to be a state crime. Okay, let's look at the elements, and we're still looking at substantive law here. So I'm going to put substantive law here. Most crimes require 2 parts. We need to have an act, some action. The action itself doesn't have to be unlawful, but it has to advance the behavior towards that unlawful goal. We also need a particular state of mind. So let me give you an example of a criminal act. I am planning on killing my spouse. I go out and buy a gun. Someone discovers in my diary that I was thinking about killing my husband. They report to the police. The police arrest me for attempted murder, and the criminal act that they may associate with me is buying that gun. But let's say I had I was eligible to buy a gun. I wasn't a felon. I was of an age that I can lawfully buy a gun, and I followed all the rules. So there was nothing unlawful about my action if I, for example, had been buying the gun just for self-protection, or because I wanted to engage in some recreational target practice or something like that. So the criminal act doesn't have to be inherently criminal, but it has to move me closer to my ultimate goal. And obviously, if I was planning on shooting my husband, buying the gun is advancing that. But let's say, let me give you another example. Let's say I was in my diary planning and thinking a lot about cheating the IRS, not with hiding some of my income from them and not declaring it and not pay taxes on it. Then I happen to go out and buy a gun. Well, buying a gun really doesn't help me in my plan to deceive the IRS. So the act of buying the gun would not count as a criminal act for the purposes of the actus reus requirement. And the phrase that you'll hear more commonly than a criminal act is actus reus. And again, this is a Latin expression, and it means guilty act. This goes back to the idea that we don't penalize people for thoughts alone. If in my mind I happen to fantasize about killing my husband, but I don't actually do it, guess what? We don't consider that a crime in our society. There's lots of reasons we don't. One is that how do we know what people are thinking? If we're going to start pretending that we have a way to read people's minds, well, I don't think we do, and that sounds like we would never get to the beyond a reasonable doubt. Even if someone might fantasize about doing something, there's a huge chasm between fantasizing and actually doing it. Probably most of us at some point in our lives have thought to ourselves, oh, wouldn't it be great if something bad happened to such and such, even though we had no intention of actually harming that particular person. So we need some kind of criminal act that's going to advance the plan. Then we also need a particular state of mind. We have to intend harm. Well, actually we don't have to intend harm, but our actions, it has to be reasonable that our actions, that we ought to know that our actions are likely to result in harm. So let's imagine that I have epilepsy. And when I have an epileptic seizure, I don't have any warning beforehand. So I'm sitting next to somebody, and the way that I have an epileptic seizure is that my arms tighten up, all the muscles tighten up. And so if I was holding my arms in a certain way at that moment, my arms would straighten and I might hit the person next to me pretty hard at that time. And let's say when I did this, I actually caused them some significant injury. They're hurt. I mean, they may not really care why they got punched. All they know is this is hurting. And so they may think, I've been assaulted. I want to press charges. I have an act. I did, in fact, it was my fist hitting that person's face. But I didn't have a state of mind. I didn't have any kind of intent. I wasn't in control of my body at that time. So I didn't satisfy, so the state of mind requirement isn't satisfied. Now, I will tell you, not every single crime requires a particular state of mind. There are some crimes that don't require it, but certainly the vast, vast majority do. Now, the mens rea that a person has can affect the seriousness of the crime. Let's think again about the whole homicide situation. In every homicide, somebody ends up dead, right? I mean, the person's just as dead no matter what the mens rea is involved, but we penalize those in very different ways. We might kill one person and give another person just a short time in jail, and it's because of the level of intent. That's the major difference between the types of behavior in that situation. So let's go back to our statute here. I'm going to go back to this and we're going to look at manslaughter. A person commits an offense if he recklessly causes the death of an individual. Well, the word reckless here suggests it's kind of an accident. I mean, he should have been more careful, he should have been more responsible, but you know, he was being pretty reckless. So imagine, for example, that I am driving along and somebody dares me to put on a blindfold while I'm driving. And while I'm driving, I'm in a bad car accident with my blindfold on, and some pedestrian is killed. Well, I might well be charged with manslaughter, even though I didn't want to kill that particular pedestrian or really any pedestrian. But I engaged in behavior that I knew pretty darn good chance that somebody's going to end up being hurt. I didn't intend it, but I knew that that was kind of the logical outcome of what I was doing. And so in those situations, the mens rea is satisfied. Let's go to the next slide. Here we go. Oh, okay, let's talk about the topic of corporate criminal liability. This is a section that I encourage you to spend some time on because this is a pretty commonly missed a question that is on one of the tests. And so it's a little bit not what we expect to be the case. I think this is a little bit counterintuitive. So flag this one when you're looking at your notes. A corporation, of course, isn't a human being. It is, in some sense, a legal fiction. A corporation can't do anything. It is just a document filed in a state. It can have agents and employees, and those people can do things. But in and of itself, JCPenney Corporation, Texaco Corporation, none of those corporations can do anything without a human being actually doing something bad. And so, so when we look at corporate responsibility, the court isn't going to excuse a corporation simply because, well, it can't do anything because it's not a human being. If I am an employee of that corporation and I commit some crime that is advancing the interest of the corporation, let's say I pay a bribe to a foreign official, and that bribe paying is going to help my employer, the corporation, make more money, then very likely the corporation is going to be held criminally responsible, as am I, of course. That's a given that I'll be held responsible, but the corporation will also be held responsible. Now, of course, you can't throw a corporation in jail, but you can fine it, and you can have it provide other penalties for it. So that's probably not that surprising that the corporation can be held to be criminally liable and, of course, civilly liable as well. The part that I think throws people is this next part. Criminal directors and officers may be personally liable for their own crimes and those of employees under their supervision. Okay, the first part's not surprising. If an executive commits a crime, bribes someone, for example, of course he or she's going to be responsible for his or her criminal behavior. But this next part, I think, is the part that's surprising. If you are an executive or a manager and one of your subordinates whom you were responsible for commits a crime that's related, of course, to the corporate activity, then you could be held criminally responsible for it, even if you didn't tell them to do it, maybe even if you didn't know it was going on, because you have the obligation to know, to monitor, to check on things. And of course, it's going to turn on how flagrant the employee's behavior was. Usually, you know, it's going to have to be a situation where you should have known, you should have been paying attention, and you didn't. And so, you know, obviously, if you have an employee who's very sneaky and somehow managed to hide it from you, and you really weren't in a position to know, it's very unlikely you'll be criminally prosecuted under those situations. But the takeaway is it doesn't have to be your own behavior. It can be the behavior of employees under your supervision, and you can go to jail for it. That's the part that's surprising to folks. Okay. Some of these are substantive and some of these are procedural. Okay, let's look at defenses to criminal liability. One is a lack of intent. Now, I would say this really is not a pure defense because you have to have, as we saw when we were looking at the statutes, one of the elements of the crime, let's go back to the statute here, is the intent. So we can see a person commits an offense if he recklessly causes the death of an individual. So the intent threshold is recklessly. When we look at criminally negligent homicide, let's look at where the intent is. A person commits an offense if he causes the death of an individual by criminal negligence. That's the intent element. Let's look at some of these others here. In this section, here we go. A person commits an offense if he intentionally or knowingly causes the death of an individual, or he intends to cause serious bodily injury, or he commits or attempts to commit an act clearly dangerous to human life that causes the death of an individual. So there's actually 3 categories here. So you can see in each one of these cases, the substantive law discusses the intent requirement for the particular action. So to say that a defense is lack of intent really is misleading, because what you're really saying is that the state hasn't proven its case. So it's not, the criminal defendant isn't required to prove lack of intent. The burden is on the prosecutor to prove whatever level of intent is required in that situation. This next one, you could call it a substantive element. I'm going to, but you could also argue that it's a procedural element. So I'm going to put substantive here, but I can see arguments both ways. And this is a true defense, or actually 3 defenses. This is the idea that I can defend myself. If I'm minding my own business and someone comes up to me and tries to grab my purse, and I shove them to the ground so that I can protect myself, because they're grabbing at my person, then I have engaged in reasonable defense of myself. And even if that person is injured, I'm going to be okay because I was acting reasonably given the provocation, given my need to protect myself. Let's say, though, I come upon somebody who is manhandling an elderly person. And under those situations, then I punch them in the nose, they're injured. Well, I was engaging in the defense of others. My behavior was reasonable under those circumstances, and so therefore I'm going to have a defense. This defense even extends to the defense of property, although obviously when you're not talking about human life, it becomes a weaker defense in this situation. So if someone's trying to grab my purse, and let's say they let go of my purse and they run away. Let's say I kind of shove them, they let go of my purse and they run away. I can't shoot them then, because they're no longer a threat to me if they're running away, number one. Number two, well, the worst thing that was going to happen would be that they stole my purse. Not a good thing, but not something that's worth a human life. And so into those situations, you have to be careful with defenses to property. We're not talking about kind of lethal levels of defense. Let's talk about the castle defense. This is an important issue. It is available in Texas and it's available in some other states, but it's not available in all states. In fact, the traditional common law did not provide for a castle defense. Before we go into what a castle defense is, well, let me first of all talk about what a castle defense is and talk about how the law can vary in this area. As you might hear in the name, when we talk about a castle defense, we're really talking about the idea of every person is the king or queen of his or her own castle, no matter how humble it is, his or her own home. And the idea is, back in medieval times, the king or the queen, the monarch, was the law in his or her domain, in his or her castle. And the idea kind of extends to some extent to modern people, at least in Texas. When we are at our home, we are kind of the sovereign in our household, and we have the right to defend it just like a king has the right to defend his castle. So if I am home alone or with other people in my own home, and let's say a bad person comes to my house, and I know that they are a bad person, and um, I kind of have a choice at that point in time. I know that I'm in jeopardy. I can flee if I can do so safely. Maybe I can run out the back and go to some safe place. I certainly can do that legally, but I don't have to do that in Texas. I can stay in my house and uh, take action to protect myself, even potentially lethal action if that's required. Now, obviously, if I say I've got a gun and they say, okay, I'm running away, and they run away, I can't shoot them running away. But if I can see that maybe they have serious weapons, and they aren't acting too concerned about the fact that I have a gun, at some point to protect myself, I can use up to and including lethal force. In Texas, the castle defense extends to my own residence, to my place of business, and also to my vehicle. It wouldn't probably apply to a place that I was staying as a guest. Probably wouldn't apply to a hotel room unless that was my residence at that time, meaning I didn't have another home. So that's kind of the scope of the protection. Let's talk about how this idea applies in other jurisdictions. About half of states in the United States have the castle defense, and about half don't. The traditional common law did not provide for a castle defense. The traditional common law said this: if being in one's home doesn't give you any additional rights than you do in the public. Let me go back to the example. Let's say that instead of being at my home at the time that these bad people came, I was shopping at the mall, and bad people came in, and I could safely flee without putting myself at risk or putting other people at risk, and I didn't need to protect other people. Under those circumstances, then I ought to flee. I ought to leave that threat situation. Call 911, obviously, get the police involved. But if it's better for me to exit the situation instead of using a self-defense technique. Now, sometimes you can't flee safely, and then, of course, you can use self-defense, but you ought to explore the idea of, can I flee safely? And if I can, that's my obligation. That's the law in Texas as well. There's just those three carved out areas of our home, our place of business, and our vehicle. In states that don't have the castle defense, the obligation to flee applies in any place, including those three locations. Many of y'all may have heard of the Trayvon Martin, George Zimmerman case. Mr. Martin was a teenager, African-American teenager, who got into some kind of altercation with George Zimmerman, an adult, and neither one was in their home at the time. They were out kind of in public, and Mr. Martin ended up dying from a gunshot wound from Mr. Zimmerman. And Mr. Zimmerman claimed that it was self-defense, that he was protecting himself. But Mr. Zimmerman, in some sense, got into the conflict. He, in some sense, I don't want to say sought the conflict, because that wasn't his claims. And obviously there was a factual dispute as to what happened. There was Mr. Zimmerman's account, and there were other people who had different accounts. But Mr. Zimmerman, who was, I think, a neighborhood watch person, saw Mr. Martin and thought Mr. Martin's behavior was concerning and maybe indications of some kind of criminal mischief, and so engaged with Mr. Martin. He didn't flee from the situation, as would ordinarily be the obligation if Mr. Zimmerman felt in personal danger. Now, there would have been no, in Texas law, there would have been no protection for Mr. Zimmerman as a castle defense because Mr. Zimmerman at some point in the matter was in his vehicle, but he left his vehicle, and so the castle defense no longer applied. In the state of Florida, apparently there's a statute called something like stand your ground, which sounds like it might be more extensive than the castle defense. It may actually have completely removed that requirement that the person flee if they can do so safely. Unlike the castle defense, which is limited to particular areas, it might be just a generalized, anywhere you are, you're allowed to stand your ground, you don't have to flee. So there might be a difference between Florida law and Texas law in this situation. Just wanted to kind of introduce those ideas to you. There will be at least one test question on the final about this, so you do need to have some familiarity with it. Another defense is the statute of limitations, and this is a procedural defense. If the prosecutor files a lawsuit after the statutory period for that particular crime, then all the defendant has to do is point that out, and it doesn't matter how strong the evidence is of culpability, that matter can no longer be prosecuted. Mistaken identity, this is not a true defense. This is kind of like the lack of intent. It's not a true defense. This is a substantive matter. Again, going back to the example of I have an evil twin, I'm saying it's mistaken identity. The eyewitnesses who think that it was me are actually confusing me with my evil twin. When you have a mistaken identity case, what you're saying is a prosecutor is misunderstanding the facts. It's a prosecutor's obligation to prove that I was there and that I committed the acts. If there's a case of mistaken identity, I'm saying I really wasn't there. You really haven't proved that act. But certainly that can be an important dispute in a case. Alibi is also not a true defense. It is a substantive matter, but it's oftentimes treated as a defense because there's certain evidentiary rules that are a little bit different about an alibi. Most of us, I think, know what an alibi is. Imagine that I've been charged with murdering Bob, and one piece of the evidence that I'm going to put into evidence at my trial is that I was actually having dinner at Applebee's with Sue. And not only will Sue testify that I was there, but Applebee waitress will testify I was there, and I have a receipt from Applebee's that shows that I paid for my meal at Applebee's at about the time that somebody was shooting Bob. So, it could have been in two places at once. It has my signature on it, so it appears to be me. So my alibi is my time supposedly at Applebee's on that date. If I really was there, then obviously I wasn't murdering Bob across town. And so that kind of fits into that mistaken identity situation. There's a dispute about the facts. I'm saying I wasn't there, and here's my reasons why I think the jury ought to believe me. The reason why alibi is kind of treated as a defense, though, is because in most criminal cases, there is no obligation or most criminal situations, there's no obligation for the defendant to tell the prosecutor anything. He has the right under the Fifth Amendment not to self-incriminate. He can not share with the prosecution what his theory of his defense is going to be. But there's an exception to that, and that is the alibi situation. And in most jurisdictions, including Texas, the criminal defendant has to tell the prosecutor if he's going to present an alibi. He's going to say he was somewhere else, or some other person will be able to confirm that he wasn't there. The reason for that is that if you didn't require that the defendant share that information with the prosecutor would be in a very difficult position to impeach that alibi. Because he or she may not know anything about the person who is serving as the alibi, doesn't know what that motivation that person is or what the criminal background that person might be. I'm saying that I was eating dinner at Applebee's with that waitress, and that waitress testifies, well, maybe I paid her a huge bribe to testify. The prosecutor can't check the witness's bank account to see if she's just had a deposit of $10,000. He doesn't even have the ability to find out quickly whether this waitress really does work for Applebee's at all. Maybe she's lying. Maybe she's never worked for Applebee's or didn't work for Applebee's at that time. criminal trials oftentimes just are 1 or 2 day or even a few hour deals. And so if the defense presents a witness that the prosecution knew nothing about and testifies to facts the prosecution has no familiarity with, it's pretty difficult for the prosecution to respond. There might be a wonderful explanation. Yes, this witness has been prosecuted and convicted of perjury 4 times before. If only if we knew what the alibi was going to be, we could have researched this person and been able to present that information to the jury. So you can see why alibi is a little bit of an exception to that general rule that the defense doesn't have to share its theory of the case. Improper police procedures is obviously a procedural issue, no surprise there. And this is a defense. Imagine that there's a ton of evidence that I killed Bob. I mean, 10 rabbis, 10 priests, 10 imams all saw me shoot Bob. But the police want to put in evidence that the gun found in my apartment, which ends up being the same gun that fired Bob, they want to put that into evidence to show not only do we have all these witnesses that say Groover shot Bob, but we even found the gun in Groover's apartment. But you know what? The police didn't follow the proper procedures. They didn't get a search warrant. They didn't get my permission before they went in and searched my home. And so I might well be able to preclude or have the court preclude the testimony or the evidence, the gun, from the jury being able to see that. So that can be a way for me to keep that evidence out. Still, the 30 people who saw the crime are still going to be able to testify, but the jury may never hear about the gun. Okay, so we talked about dividing up crimes in terms of their severity: felonies, misdemeanors, and petty offenses. But another way of dividing up the universe of crimes is not to think about the level of seriousness of the crime, but the subject matter of the crime. So we can divide it up by looking at it as violent crimes. This would be, murder, assault, rape. Those would be examples of violent crimes. You can have property crimes like arson, larceny, things that are designed to get money, burglary, something along those lines. You can also have public order crimes. These are usually those kind of victimless crimes we talked about before. Property is usually not damaged, at least not damaged severely, and nobody is hurt. Public drunkenness, prostitution, illegal drug use. Those are examples of that. But we also have white-collar crime. Now, white-collar crime is usually going to be a property crime as well. Many times people think about white-collar crime as kind of not so serious of a crime. The reality is that white-collar crime is a very serious crime. It's typically, at least on the surface, a nonviolent crime, but the repercussions that can happen in society can easily compete with very serious violent crimes. Think for a second about Bernie Madoff. Bernie Madoff had a Ponzi scheme. He was a very important, well-respected Wall Street person, and he took a lot of money from people, some of whom had a lot of money, some people who didn't have a lot of money. And when the scheme was discovered, there were lots of people, not a lot, maybe exaggerated, but certainly there were people who committed suicide over it, whose lives were dramatically changed as a result of it. And so the idea that white-collar crime are not that serious is just not true. Certainly there are more serious and less serious white-collar crimes, but they can be very, very serious matters. Then we have organized crimes. Organized crimes can be violent crimes, they can be property crimes, they can even be public order crimes. They can even be white-collar crimes, so this can cross categories. This is where you have crimes that involve illegal goods and services, but there's some structure to the criminal enterprise. You have more than one person. There may be a mafia kind of tie, or an organized crime, a gang kind of crime. where there's a thought out plan to how the crime is going to be committed. An important statute in this area is RICO. And there's both federal RICO statutes and state RICO statutes. And what RICO stands for is the Racketeer Influenced and Corrupt Organizations Act. RICO claims can be pursued both as criminal matters and as civil matters, and there are very stiff penalties under both ways of pursuing the matter. They're designed to address these types of problems. Organized crime is a very serious problem because, well, for lots of reasons. One criminal acting alone is not a happy or good thing. But once you have a network of criminals acting, it becomes increasingly exponentially difficult to kind of crack the case and to solve the problems that arise from that. And so that's why we're so concerned about organized crime in these areas. Another category of crimes are cyber crimes. Cyber crimes are going to be typically property crimes, probably the most common, or public order crimes. You can't have direct violent crimes, although you can have threats over that can be cyber crimes. And when we're talking about cyber crimes, again, we're talking about things that relate to computers. You can have identity theft or other financial crimes. You can have cyber stalking, where you're harassing somebody through monitoring them through the internet, through computers. You can have cyberbullying, where you kind of traumatize somebody. Oftentimes these are younger people who maybe become so distraught that they harm themselves. And so again, very potentially serious issue. There are lots of difficulty with cyber crimes, proving, we have some more crimes, we'll talk about this in a second. Hacking is another, obviously, cyber crime. Getting into, it's really like a property crime, in that you're, just like if I were to burglarize your home, if I hack into your computer, I'm burglarizing your data. Similar idea. And of course, sometimes hackers are doing it to steal something from your computer or take your computer over. Sometimes they're doing it to harm that particular person, either for a malicious reason or just because they can do it. So let's talk about the prosecution of cybercrimes. These present a lot of challenges. Imagine, for example, that I am engaging in hacking of Bob's computer. Bob's computer is in Minnesota, I'm in Texas. Well, did the crime take place in Minnesota or did it take place in Texas? And what laws apply into those situations? And if I'm able to hack into Bob's computer, I probably have a pretty sophisticated understanding about how computers work. So it may be very difficult for law enforcement to track down exactly where I am and how I did it, certainly when the burden of proof is beyond a reasonable doubt. So there's lots of challenges with this particular prosecution of crimes. Some of these issues are resolved using federal statutes, so then it doesn't really matter whether I'm in Texas or in Minnesota if it's a federal crime. Of course, then it becomes an issue. Well, let's say I'm not in the United States at all, but I'm in Canada, or I'm in Russia, or I'm in Nigeria or some other place. Well, then the fact that it's a federal crime doesn't help us because it's now an international crime. So this is definitely a challenging area. Now we're going to talk about the Constitution. And again, this is the part of the course, really the only part where we're going to go back here. Let me just talk about this here. So all of these crimes that we just talked about are substantive. So substantive, of course, these are substantive. And these are substantive. This one is substantive. This one is procedural. In here, in this category, we'll see both substantive and procedural. As I said before, this is really the area of the law that has most connections to the Constitution. We all know that the U.S. Constitution gives us lots of protections against government action. That's what it's primarily focused on, especially those first 10 amendments, which are the Bill of Rights. the Bill of Rights protects us from the government. It doesn't protect us from each other. Initially, it just protected us from federal government, the federal government action, but nowadays it also in many ways protects us against state government action as well. And the idea, again, is that idea that individuals don't have nearly as much power or resources as the state. So these constitutional protections are a balancing of the rights of the individual versus the society as a whole. We think about our Bill of Rights as being kind of new ideas, and they certainly were very important ideas. But many of the rights that we see in the Bill of Rights have an existence prior to that time, that they were part of the English Constitution. The English Constitution isn't a written document the same way that ours are, but some of the ideas go back to the Magna Carta and to other important English law traditions. So there's they weren't all new ideas, I guess is what I'm saying. So we're going to focus on just a few of these protections, the ones that relate to criminal law. The first, actually, let's pull up the U.S. Constitution here for a second. So I'm going to flip to a resource to pull that up. Let me go to Google. Not sure where I ended up there. Okay, so we're going to scroll. Of course, the amendments come after the articles to the Constitution. Okay, we're going to have to get the amendments in a different place. Okay, I just want the text of it. Here we go. Maybe this will get it for us. Okay, here we go. So here we have so this numbering is different than what we're used to. Okay, here we go. So we're going to look at the Fourth Amendment first. So here we have the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That's our first amendment. And so here's kind of a summary. The Fourth Amendment prohibits unreasonable searches and seizures and requires probable cause for an arrest warrant or a search warrant. The next one we have is the Fifth Amendment. So the Fifth Amendment is, and you can see it's a little bit longer than the Fourth. The Fourth Amendment is really about warrants and searches. Fifth Amendment has kind of several different topics in it. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So this is the requirement to have a grand jury. Now I will tell you before we go farther that you need to have an indictment in federal court, which we'll talk about the indictment process later, but for a felony. But in many states you don't have to be indicted for felonies. In Texas you do, but it is not a requirement under the Constitution for state governments to use the indictment procedure. So this is one of the cases where the Constitution protects us differently from state versus federal action. So this is one of the elements of the Fifth Amendment. Let me start again. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall anyone be subject to the same offense to be twice put in jeopardy of life or limb. This is the double jeopardy protection. And then the next one is, nor shall be compelled in any criminal case to be a witness against himself, or and this is that right against self-incrimination. You'll hear people say, I'm going to take the Fifth or assert the Fifth Amendment right against self-incrimination. That's the clause they're pointing to. Or be deprived of life, liberty, or property without due process of law. That's that due process requirement. We actually have two due processes protections in the amendments. The one here in the Fifth Amendment, and there's one in the 14th Amendment. And then finally, nor shall any private property be taken for public use without just compensation. Now this one is kind of like an add-on. It's like, well, what does that have to do with criminal law? The rest of the items have to do with criminal law. This one doesn't. This has to do with the power of eminent domain. So this is a little bit of a grocery list, so to speak, especially with this last edition. So let's go back to our PowerPoint. And here's our summary. Requires due process of law, prohibits double jeopardy, protects against self-incrimination. Those are this is the Cliff Notes version of these statutes. And again, we're still on, these are really procedural. The Sixth Amendment, let's go back and look at the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. That's one guarantee. By an impartial jury, so we have a right to a jury trial, of the state and district where the crime shall have been committed, which district shall be previously ascertained by law, and to be informed of the nature and cause of the accusation, so the person has a right to know what he's being charged with, and to be confronted with the witnesses against him. He has a right to be present when the people are testifying, and to have compulsory process for obtaining witnesses in his favor, so he has a right to subpoena witnesses, and to have assistance of counsel for his defense. These all relate to the criminal justice system, but this is again kind of a laundry list of various rights. So let's go back and look how I've summarized them in the PowerPoint. Again, you don't have to go back and read the actual amendments. This summary is adequate for the purposes of test preparation. So the Sixth Amendment, we have guarantee the right to a speedy and public trial, to a trial by jury, to a right to confront witnesses, and the right to an attorney at various points in some proceedings. Let's stop here and look at some of these things. The right to a speedy trial is important in that in many cases a person will be incarcerated up until the time of trial. So if a person is either ineligible for bail or cannot meet bail, he might be incarcerated for months or even longer than that if he isn't entitled to a speedy trial. And so he's essentially serving his sentence before he's been convicted of anything. So that is one of the reasons why defendants are entitled to a speedy trial. Defendants are entitled to a public trial because the concern again is the power of the state. If the state could privately prosecute people, then the public overall wouldn't know about it, and so there could be great injustice. So everyone has a right to a public trial where the press can be present and there can be a record of what's happened, and so the public can decide whether something inappropriate is happening. In addition to the constitutional protections to a speedy and public trial, there are both state and federal statutes that give more specificity to this right. Now, criminal defendants are entitled to waive their right to a speedy trial, and honestly, it's pretty common that they do because, um, uh, I mean, they don't have to, but they might decide, well, that they need more time to prepare for the case. If they want more time, then they have to waive that right in order to get that additional time. The right to trial by jury is also a waivable right. Sometimes a criminal defendant might want a bench trial, might want the judge to determine guilt or innocence. In the vast majority of cases, they want a jury, but there could be times where you want a bench trial. In that situation, they certainly could waive that right. Let's talk about the right to confront witnesses. Typically, it's not going to be the criminal defendant who actually confronts or asks questions of the witnesses. It's going to be his or her attorney. But of course, sometimes a criminal defendant represents himself. We call that type of criminal defendant a pro se, or also called pro per defendant, representing himself. Those are two Latin phrases. You can imagine, though, that especially if the criminal defendant is representing himself or herself, and it's a violent crime, especially against a child, that it could be very traumatic for that witness to have to be present in the same room with this person who traumatized him, the child, and to have to interact and answer questions. And so there are times where the right to confront witnesses, in especially disturbing cases, the criminal defendant might actually be watching the proceedings from a remote location. Even under those situations, though, he's going to be able to see everything. There's going to be some kind of camera and microphone that's going to allow him to see what's happening, to hear what's happening, and he will have the opportunity to consult his attorney, to suggest questions that could be asked of that witness, that type of thing. And of course, he will be eligible to call witnesses to support his particular assertions. The right to an attorney is part of our Constitution from the very early days, back in the first decade of our country's existence. But it wasn't until the 1950s that the right to an attorney became something that the state had to pay for. The first case in this area was Gideon versus Wainwright. And by the way, there's a famous book, Gideon's Trumpet. Won lots of awards. It's a great book to read. In that particular lawsuit, Mr. Gideon had committed, I believe, a relatively, I don't say minor crime. I think he might have stolen some cigarettes or something along those lines, but he had committed several crimes, maybe some barroom brawls and things like that in his background. And so as a result of this action, he was going to perhaps face a pretty significant penalty. Mr. Gideon was an unsophisticated man. He wasn't well educated. He didn't have financial resources. I don't even know if he could really read and write. He certainly didn't know much about the justice system. He didn't have any friends in the community or any family, I don't think. And so he didn't really have the ability to investigate his case. He couldn't pay bail, so there was no opportunity he had to find his own witnesses. And there was no law library in the jail that he could go to consult and learn about how to represent himself. At that time, though, he had no entitlement under the law to any kind of representation. Now, the person who would be representing the state was an attorney who had lots of resources, the police and probably other people on staff who could go out and find witnesses and were very familiar with what the law required. So it was a very unequal playing ground. Well, Mr. Gideon requested the appointment of an attorney at the expense of the county. That request was denied, and so he represented himself, and he lost, but he did continue to advance this objection to the process, and eventually he was successful, and he was entitled to another trial where he could get the state, in this particular case the county, to represent him. Initially, the protections were only for pretty serious crimes. Nowadays, it's usually to a crime that's going to involve incarceration for a matter of months, where you have that right to an attorney to be appointed without any charge if you lack the funds. And again, there's a whole series of cases on this topic. So let's now go to the Eighth Amendment. So we have Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So that's where we have the Eighth Amendment. Relating especially to the Fourth Amendment, and to some extent the Fifth Amendment, we have the exclusionary rule. And this is the mechanism that the Fourth Amendment protections actually play out. Because while the police have to have that search warrant, sometimes they haven't always followed those rules. And so there really wasn't a penalty for them not following the rules if they were allowed to put that evidence into the record. And so what courts did is they said, well, there needs to be a penalty, and the penalty that will impose upon the prosecution, the police in this case, is that they can't put that evidence in. That will be excluded from evidence. And also evidence that they acquired as a result of that improper search will also be excluded. Now, the reason that the evidence is being excluded is not because it's not probative, it's not good evidence. Evidence found, for example, if I killed Bob or I shot Bob, the gun found in my apartment is pretty powerful evidence that maybe I was involved in shooting Bob. So it's not being excluded because it's not strong evidence. It's being excluded to penalize the police so that the police will know we're not going to engage in that kind of behavior going forward. Let's consider the Miranda rule. It's one of those legal rules that's probably the most familiar to lay people. It's what the police say to people who are being arrested. You have the right to remain silent, et cetera, et cetera. It is due to a case. In this case, the criminal defendant was someone with the last name Miranda, and it was decided in 1966 by the U.S. Supreme Court. By the way, you're not responsible for this date. You don't need to know this. And what it means is that when someone is taken into custody, they have to be informed of certain of their constitutional rights. And the idea here is, well, if the person has constitutional rights but doesn't know what they are, in a way, they really don't have those constitutional rights because they can't really use them if they're not familiar with them. And so if the police don't provide those warnings, in some cases, the evidence that the police might acquire through an interview of that particular person in custody won't be admitted into evidence. That's not always true. There are times where it can still be admitted into evidence. Here is the famous Miranda warning. You have the right to remain silent. Any statement made may be used against you in a court of law. You have a right to an attorney and to have an attorney present while being questioned. If you cannot afford to hire an attorney, the right to have an attorney provided at no cost. And so a person can waive these protections, but they have to have that opportunity to be aware of what those protections might be. So up to this point, we've mainly been talking about substantive, and now we're going to focus on procedures. So I'm going to stop the broadcast at this point, and we'll start on slide 18 for our second lecture. I thank you for your attention, and I will be seeing you in the next video. Have a good day.